Hi guys, welcome to my channel. So a couple months ago, I did a video talking about the short-term rental market, short-term rental industry, and what was about to come and what was about to hit New York City. So the law just finally came out in November, December of 2022. So keep in mind, they're still working out the implementation process of this, or how they're going to implement this. That's still being worked out. Also, maybe about a week ago, they allow people to sit in the hearings. There's still some new things that are being added to this law. So we don't have the full infrastructure yet, but the law is on the books, and this is what it looks like. So what I was able to do here, I was able to actually get the actual bill. All right, so we're gonna take a look at it together. I've highlighted key points, key points here, which I think are important. I'm gonna put the link in this video. If you guys wanna go ahead and read the entire bill yourself, you can go ahead and do that. But what I've highlighted some interesting areas and some interesting points that I wanna talk about with you guys today. All right, so let's take a look. So we're looking at the bill. Mayor's Office of Special Enforcement. So this is the OSE. So basically they are a special agency part of New York City that will be enforcing the short-term rental rules and building codes and so on and so forth. All right, so scrolling down here, let's take a look. All right, so it's all this boring stuff. You guys can go ahead and read some of that stuff yourself. All right, so here we go. So Section 21 of this rule, short-term rental registration required. A person who owns, manages, occupies, or otherwise control a dwelling unit shall not offer, manage, or administer short-term rentals of such dwelling unit portion. So basically, if you own or if you manage your agency or anything on that term, you are not allowed, based on this new law, to do short-term rental without a registration process. So you have to register that unit and you have to get a registration number, right? And the registration number has to be registered and is valid, right? And also too, part of this bill, I think later on they mentioned this also too. So each time you rent it, that number has to be added to your listing as well. All right, so the requirement of this chapter does not apply to short-term rental of Class B multiple dwelling or Class B dwelling units within mixed-use buildings. So what is a Class B unit? Class B units are what is a Class B unit? Class B units are short-term buildings. So for example, hotels, so on and so forth. Those are considered Class B building. Class B building is more of a transient types of building, right? So hotels, people that are staying there short-term. Class A buildings are more for permanent use. So apartment buildings, condos, co-ops, and so on. Those are considered Class A buildings, okay? Short-term rental registration application and approval procedures. All right, so I just highlighted this part here, right? It says, an applicant must be a permanent occupant of the dwelling unit. An applicant may not apply for more than one short-term rental registration number. An applicant may not host short-term rentals in more than one dwelling unit. All right, so this is what they're talking about here. So when they say an applicant must be permanent occupant of the dwelling unit. So meaning if you have a two-family home, if you have a two-family house, and you live on the first floor, let's say, and then you want to rent out the other, you want to rent out the upstairs unit, you're not allowed to do that. You could only rent if you're actually living and residing in that unit, right? So let's say you have a 2-bedroom apartment or in your private home, 2 or 3-bedroom apartment. You can only rent one room, not more than one. Also, this says, an applicant may not apply for more than one short-term rental registration number. So, and each unit has a registration number. So you understand? So let's say you have a 3-bedroom apartment and you live in 1 bedroom and you want to rent out the other 2 rooms, you can't do that. You could only apply for one registration number for one of those units. I mean, for one, each room will be considered a unit. You're not allowed, based on the law, you're not allowed to rent in New York City an entire apartment short term for less than 30 days, if it's an apartment, you're not allowed to rent out an apartment for less than 30 days. That would violate the New York City short-term rental laws. Even if you live in that building, if that other unit is a full apartment, let's say a 1-bedroom apartment, 2-bedroom apartment, you're not allowed to rent that unit out on a short-term rental basis, meaning less than 30 days. That is illegal, unless you live in that apartment and you're sharing it with people. And also it says no more than 2 people. So let's continue. Applicants that are tenants shall also provide a lease that describes the period of tenancy. If the applicant does not have a lease, the administering agency may accept other documentation that establishes that the applicant is legally entitled to occupy in the period of which they're entitled. All right, so this is self-explanatory. So if you don't own it, you're a tenant, you have a 1-year lease, 2-year lease. Each registration is for 2 years. If you have a 2-year lease, if you have, let's say, the registration is for 2 years, it's good for 2 years. So if you have a 1-year lease, but the registration is good for 2 years, if you extend your lease, you must provide with documentations and so on and so forth. So this is basically self-explanatory. The rest of this here tells you what you need to register, ID, what kind of ID you need, and so on and so forth. So you guys can go through that and go ahead and read that yourself. Also, what they want you to, what those basically, this section right here, what they're talking about is if you say you live in a co-op, you live in an apartment building, and you file for an application for a short-term rental, they will notify the HOA board or the landlord or whoever owns that property. They will be notified that a short-term rental application has been filed. All right. And most importantly, right, so the application fee is $145 and is non-refundable. So they'll take your money, they may deny your building for whatever reason, but they're not giving you back that $145, okay? The city needs money. All right, so yeah, so keep reading. You guys can go through this yourself. All right, so this is another interesting part of this here. It says, term of registration, expiration of registration. So the term of the registration shall be for 2 years, except as provided in section B. So this is what I just explained. So in case where the applicant right to occupy the unit will terminate in less than 2 years. So let's say 1 year, you can file for an extension and so on and so forth. All right. So for those of you who have 1 year leases and you want to apply for an application. All right. So let's keep going. No short-term rental registration or renewal shall be issued unless the administering agency has verified that the occupancy classification of the dwelling unit allows a residential occupancy, right? So for example, they have to, so you cannot rent it, you won't even get an application, they won't even give you an okay unless they verify your building, your occupancy. All right, so no short-term rental registration shall be issued or renewed for a rooming unit. So basically SROs, I would say, right? SROs stand for a single room occupancy. All right, the part right here in yellow. So basically, this talk about rent control. So if you live in a rent control building, rent control, rent stabilized, any of those buildings, NYSHA, or anything that has to do with the city, they'll take the money for the application, but they won't even consider you. You're part of what they would call a prohibited building list. So you're out. Next, the administering agencies shall not approve a registration of renewal application that includes any listing or listings identify that advertises illegal occupancy, including listings that offer the unhosted rental of an entire unit, or that offers or appears to offer occupancy to move than the lawful number of roomers, boarders, or lodgers permitted by Section 2724 of the Housing Maintenance Code. So basically, what this is saying is that the agency would not approve an application that where it appears that the person who's applying is not going to reside in that unit. So meaning even if it's your own home, yeah, and you're gonna rent, let's say, an apartment in your own private house, if the agency, if they suspect, based on the investigation or whatever, that you're going to rent an entire apartment and you don't reside in that unit, they will deny your application. Or if you're renting a room, if it's more than two people, that's the number that they're working out right now. So they're throwing this new number out. They actually coming up with an actual number. No more than two person. If they think that it's more than two people, I don't know how they're gonna do that. But yeah, you will be denied as well. You'd be in violation of their rules. Prohibited building list. Okay, so this one here. You know, I was reading an article. I saw people were up in arms about this, and they call it controversial. But it's, you know, after reading the actual bill and looking at it, it's not so controversial. Let me explain. So, basically, what this is saying is that if you have a condo or a co-op, you can register with the city on a prohibited on a prohibited list, meaning the HOA of the co-op or condo, they can vote or send it to the city and say, look, this building here or this address here, we're prohibited from short-term rentals, or we're not allowing short-term rentals in this co-op and condo. And what I think a lot of people read into it as, well, if I own a condo, then the board can vote to allow short-term rentals in this building and it's gonna be okay. No, right? So this is, if you look further down, it says, inclusion or lack of inclusion of such lists does not alter and may not be deemed to alter the legal occupancy or zoning use group of a building or portion thereof as described in the certificate of occupancy or as otherwise determined by the Department of Buildings. So meaning, if you have a condos and co-ops are classified as multiple dwelling building A. So meaning that they are meant for permanent use. So then so earlier in the law, it says that if buildings that are considered class A's, they're prohibited. They will not even give you a permit or a number. You're part of prohibited list unless your building classification is a class B. So co-ops and condos are class A buildings, which automatically would make them not qualify for an application. So that answers that. So I just want to clarify that because I saw online what the article was saying. You know, when a lot of landlords, a lot of people that went down there for the hearings, they thought that was very unfair that the city would allow condos and co-ops to vote on whether they would allow short-term rentals. And that it would be okay, it would be legal. So basically on this thing is saying, look, even though you guys vote to include or not vote to include these buildings or these addresses because it's a class A, it will automatically fall in violation of the building code and they will not even issue a certificate, all right? Let's see, registered host requirements. No person shall operate a short-term rental in violation of the provision of zoning regulations, multiple dwelling law, housing maintenance code, New York City construction building code related to short-term rentals, units and private dwellings in Class A multiple dwellings or in Class A dwelling units within mixed-use buildings. So basically, yeah, you shall not violate the building code for multiple dwelling law, housing maintenance code, Class A private dwellings and Class A multiple dwellings. So, basically what I've been saying, private dwellings like your two-family homes, and Class A buildings, basically multiple dwelling units, co-ops and condos, and so on. A registered host shall retain a record of each short-term rental transaction for at least 7 years. Each short-term rental is a separate transaction. Each transaction record shall include the following information. So basically, you have to hold on to this for 7 years. And let's look a little further down. In accordance with the applicable law, upon request by the administering agency to provide the transaction reports in this section, registered host shall have 10 business days to provide the requested records via a secure portal. So you have 10 days. So if they request that information, you have to hold it for 7 years and you have to provide it to them. Not providing this information to them within that period of time, I think there's a fee associated with that as well. So there's like first violation fee, second violation fee. If they're not receiving this information, obviously it goes up and up and up each time, all right? A registered host shall not allow a rentee to have exclusive access to a separate room within a registered dwelling unit. Providing a rentee with a key to lock the door when such rentee is not in the dwelling unit is prohibited. Let me repeat that. Providing the rentee with a key to lock the door when such rentee is not in the dwelling unit Providing the rentee with a key to lock the door when such rentee is not in the dwelling unit is prohibited. So yes, it's not allowed. All right. Excuse me for that. All right. So this is here, the trinkets right here, the fees, the fines. Failure to timely notified administrative agency of changes to information provided by the applicant in connection with a short-term rental application. First offense, $100. Here we go. All these fees. You guys can go read it yourself. Failing to maintain a record of each short-term rental for at least 7 years after such short-term rental occurred. So this is $500. This is for your first violation, 500. Your second, you get the idea. All right. Anything else that I put on here? No, I think that's it. Yeah. Oh, here we go. So basically, this is just for Airbnb. They also could get fined if they don't with their transactions. Just a little bit. This one here is a little bit more technical, but there are also fees and fines for Airbnb as well for operating in New York City. So. Well, guys, there you have it. I know this video is a little long, so basically I just wanted to try to cover as much of this as possible so I can provide a lot of that information for you guys. So a lot of the proponents of this new bill, are saying, well, the reason why we need to do this because Airbnb is causing rent in New York City to go up, is taking much needed housing stock off the market, people renting their housing short term. So we have to come up with these crazy laws to basically help with the rental prices. And I'm like, this is completely ridiculous. This has nothing to do with that, okay? Is the city basically trying to get some money off of this? And actually, once again, these laws screws the middle class, okay? So people who work hard, let's say you have a 1-family or 2-family home and you're trying to rent, because maybe you had a nightmare story, you have a nightmare tenant story, so you do not want to rent anymore, you want to do short-term rental Airbnb, you're out, you're done. The city is not allowing you to do that, all right? So once again, you're going to get screwed. Even the city themselves have admitted there are about 10,000 illegal Airbnb listings throughout the city. 10,000 Airbnbs that is not the reason why rents are expensive in New York City. Rents has always been more expensive in New York, but 10,000 so-called illegal Airbnbs are not the reason why rents are becoming more and more expensive in New York City. Check out this article from Bloomberg. New York City landlords bracing for millions in fines with new climate law. Landlords for thousands of New York City properties are bracing for fines from a new emissions law that will come into effect next year, 2024. Under the new rules, up to 3,700 properties could face total penalties exceeding $200 million a year. A study by engineering consulting firm level infrastructure showed by 2030, up to 13,500 buildings could face fines totaling more than $900 million a year, according to the study commissioned by the Real Estate Board of New York, an industry trade group. That is why the rent is going up. That is why rent is becoming more and more expensive in New York City. You have insane laws like this. How much money do you think is going to cost these landlords to retrofit these buildings? Do you think now that's going to make rent less or more expensive? This is my 2 cents, guys. Let me know what you think. Please leave a comment in the section below. I do read them. I will respond to them. Share this information with your friends. Share with anybody who's looking for this information or you think this information might be helpful to them. Thank you. I'll see you soon.